In a medical malpractice case, during the course of your question and answer session known as a deposition, during the pretrial process, when the defense attorney asks you a question about whether you ever brought a lawsuit before, you immediately think, wait a second, I brought a car accident case before, but you know what? It's got nothing to do with this case, so I'm going to tell him, no, I've never brought a lawsuit before. Is that information ever going to come back to bite you in the butt? You want to know the answer and why it's so important? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. What you've just done by answering the question no is you've lied. You have told this attorney a lie during pretrial testimony. You are being asked questions by the defense attorney. You are giving answers. You are sworn to tell the truth. There is a court reporter present in your attorney's office who's recording all of the questions and all of the answers that you are giving. That pretrial testimony carries the same exact weight as if you are testifying in a courtroom at trial. So now when the defense attorney turns around and says, hey, Mr. Jones, have you ever brought a lawsuit before? And now you think in your mind that he's going to think that because you brought a lawsuit for your car accident matter, that somehow it's going to affect or impact your ability to bring this case and whether or not your case has merit. Your goal, your one goal, is to tell the truth. Your goal is to be credible, to be believable. Because if you say one thing that turns out to be a little white lie, guess what? The defense attorney, I guarantee you, they will find out that you've brought a lawsuit before. They will find out that you brought a car accident case. They will find out that you settled your case. It's easy to find out. And now, what have you done? You have literally destroyed your credibility. And you think, hey, what's the big deal? It's not a big deal. Well, when you get to trial, the defense attorney is going to turn that little white lie into showing the jury that you are not credible, that you are not believable. Why? Because if you lied about that one little thing, what else could you have lied about? And now they're going to shed doubt on all of your other testimony, even if it's entirely true. Even if everything you say about what the doctor did wrong is entirely true. But because you went ahead and thought in your own mind that it didn't make a difference and the defense lawyer didn't need to know it, guess what? They're going to show that you're a liar. And for something that's so meaningless, that has nothing to do whatsoever with the merits of your medical malpractice case. And that's how they will turn it around. And that little white lie can destroy your entire credibility. So why do I share this quick information with you? I share it with you just to give you an inside look at what goes on in these civil lawsuits involving accidents and medical malpractice and wrongful death here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.